Okay, beginning at our traditional 10 past the hour. Welcome to today's Civic and Moral Education Initiative colloquium. Really thrilled I'm year 11s and I'm one of the co-conveners along with Helen Hayes of CMEI and the colloquium series. We're really excited to have Michael Rebell here. He's in town all year for those of you who would like to chase him down further as a fellow at the Sacker Center for Ethics. And we're really grateful to him for coming over today to talk about schools, courts, and civic participation, enforcing the constitutional obligation to prepare all students to be capable citizens. This is something that Michael, as much as anybody in this nation, is both he's an expert on not just sort of academically, but also very much in practice in terms of how actually to change education policy and education finance in order to try to actually expand basically civic opportunities and academic opportunities to all kids. He was co-founder, executive director, and counsel for the Campaign for Fiscal Equity, which brought a very well-known case in New York, CFE versus State of New York, under which the Court of Appeals, New York State's highest court, declared that all children are entitled under the state constitution to the, quote, opportunity for a sound basic education, unquote. And then what they did is they used what it actually takes to be a good citizen, say serve on a jury, as one of the criteria for determining what a sound basic education means. It had a radically transformative effect, at least for a while, on children in the city of New York, and then the recession hit, and since then Michael and others have been just indefatigably battling to get back the transformative effect of redistribution. In addition to the work that Michael is doing on the ground, he's executive director of the Campaign for Educational Equity and professor of law and educational practice at Teachers College at Columbia. And the campaign more generally than just New York seeks to promote equity and excellence in education and to overcome the gap in educational access and achievement between advantaged and disadvantaged students throughout the United States. Michael has also led cases not just focusing on New York City kids. He's litigated some major class action lawsuits, including Jose P. versus Mills, which involved a plaintiff class of 160,000 students with disabilities. And I actually didn't realize this, that he served as a court-appointed special master in the special education here in Boston, Allen v. Parks. So he actually has quite a connection to Boston as well as sort of around the country. He's the author of 5 books. Is it 6 now, actually? Or you're working?
Well,
this will be the 6th book. And he's just a sort of towering legend. I'm so pleased that he's here. After he talks to us, then we'll hear from Brent Maher, who many of you know as being the incredible organizer for CMEI. He's a 3rd-year doctoral student here in higher education. He studies the history of U.S. federal higher education policy, paying particular attention to the debates between government and higher education leaders in relation to regulation, which obviously we'll be thinking about today, and institutional autonomy and self-governance. He has a study recently of a loyalty oath requirement for student loan beneficiaries under the National Defense Education Act of 1958. An article on that is coming out in History of Education Quarterly soon. And before he started here, Brent was the Director of Assessment and Quality Improvement at Taylor University of Indiana. And as always, after we hear Brent's response, then we'll open it up for Q&A and full discussion, for which we should have at least half an hour. So, on to Mike.
Well, thank you very much, Mira, and I'm very pleased to be here. And I should mention that Mira's very wonderful book on the civic empowerment gap is one of the things that motivated me to go down the path that I'm going to describe to you in my current thinking and the current project that I'm working on. So, let me get into it. I'm going to speak today about schools, courts, and civic participation. And whenever I mention this topic to people, the first response I always get is, wait a minute, what in the heck do courts have to do with civic participation? We have a sense of what schools have to do with it, but what do courts have to do with it? So I guess that's the bottom line of what I want to tell you today, why courts should get involved in this, and I think will get involved in this. But first, let me focus a little bit on the school part, and then you'll see how that builds toward the court part. And what I want to first do is establish what is the responsibility of schools to prepare students for civic participation, to be good citizens. Now, to inquire into this topic really compels one to go back to the beginning of our country, the Revolutionary War era, the establishment of the United States as an independent country. And right from the get-go there, and it actually goes back into colonial history, but I won't go back that far. At the time of the Revolution, the Founding Fathers, we didn't have too many Founding Mothers, but the Founding Fathers were very much aware that they were embarking on really a new experiment in democratic government. There was much discussion, debate, civic republicanism, looking back at democratic regimes in ancient times. And they knew that this, in a new country, there was going to be a break from Europe, and this revolution was not only a war of independence from England, but it was going to be a transformative political event. And as part of that new vision of a democratic society, they were also very much aware, as Larry Cummins put it in his book, that they had to deliberately fashion a new revolutionary character. They had to create a new type of citizen that could carry out the function of this democratic society. So let me just read you a couple of quotes. John Adams, at the time of the Revolution, or at the time right after the Revolution, wrote, quote, "A memorable change must be made in the system of education and knowledge, which must become so general as to raise the lower ranks of society nearer to the higher. The education of a nation, instead of being confined to a few schools and universities for the instruction of the few, must become the national care and expense for the formation of the many." And Thomas Jefferson added at the time that it was imperative that each citizen know his rights, to exercise with order and justice those he retains, to choose with discretion the fiduciary of those he delegates, and to notice their conduct with diligence, with candor, and with judgment. So there was a general realization that the schools were going to play a really critical role in the development of a new democratic society. And that vision became a reality, really came to fruition about 50 years later, the middle of the 19th century, with the establishment of the Common School movement. And again, I don't want to take too much time to delve into the history here, but it is quite fascinating that Horace Mann and the others who called for the establishment of common school systems to take this notion of the importance of fashioning new Republican or democratic citizens to talk about establishing a coherent school system that would bring together the children of the rich and the poor under one roof. Those were the phrases that people like Horace Mann were using. And you know, the word common school really had two connotations. It was having a common system, a statewide system, instead of the hodgepodge of private schools and church schools and poor schools and all at the time. But it was also common in the sense of being egalitarian, mixing the children of the rich and the poor. But again, this notion of preparing these students for their civic roles, for their place in a democratic society, was very much in the forefront of the thinking of the founders of the Common School movement. So I'll just read you one quick quote from Horace Mann. Quote, "Education must be universal. With us, the qualification of voters is as important as the qualification of governors, and even comes first in the natural order. The theory of our government is not that all men, however unfit, shall be voters, but that every man, by the power of reason and the sense of duty, shall become fit to be a voter. The idea that the prime purpose of schools was to prepare students for this citizenship role really motivated the common school movement. As one superintendent of schools back in 1862 put it, quote, "The chief end is to make good citizens, not to make precocious scholars, not to impart the secret of acquiring wealth, not to qualify directly for professional success, but simply to make good citizens." So that's the background of our public school system. Those were the motivating factors behind its establishment. And one more landmark development in the history of American education that I just want to quickly make note of in this rapid scan of the history of education and its relation to civic participation is the compulsory education movement that developed around the end of the 19th century, and by the early 20th century, just about every state in the Union had established not only a common school system, a public school system, but a legal mandate that all children had to attend that system. Now, why were they so insistent on saying that there was an obligation for all children to attend the public schools? Well, again, I think it had to do with the idea that we had to educate students for democracy. Now, some of the motivation there may not have been quite as pure as the statements of John Adams and Horace Mann, because a lot of it had to do with trying to assimilate the new immigrants and somewhat racist attitudes that these hordes of ignorant people from who knows where must be molded into being good American citizens. But the same notion of the schools having the central role in preparing students for citizenship was behind the compulsory education movement. Now I want to start bringing in some of the legal perspective on this, because with the compulsory education movement, we had some really interesting legal developments, and a major decision of the U.S. Supreme Court from 1923 that still has a lot of relevance. This was the famous Pierce case, and what Pierce had to do with was deciding, the Supreme Court had to decide at that time, whether, given the compulsory education laws, the existence of private schools could be countenanced. In other words, many people at the time were making the argument, if we're saying that the state has a reasonable basis for insisting that all students must go to public schools, and if the public schools have as their primary mission to prepare kids to be citizens in a democratic society, the society has to control the schools, and we have to make sure that the schools all these children are attending are doing the kind of job that needs to be done. Now, interestingly, this case was brought to a head. The plaintiffs in the case were none other than the Ku Klux Klan, not from the South, from Oregon of all places, and it was part of, quite frankly, an anti-Catholic movement to say that we don't want the Catholics establishing their own private schools. We want them coming to the public schools that we, the Protestant majority, control, so we can mold them into the kind of citizens that we want them to be. Very interesting that they chose Oregon to bring this case, by the way. There were only about 8% Catholics in Oregon, but some people believe that they picked that state precisely because they could get a referendum. This is how it came up. They had a referendum passed in Oregon that outlawed private schools. And then some of the private schools in that state brought this litigation and said, we have a liberty right to be in the business of running a private school, and for our parents to have the liberty to have their kids get the kind of education that they want, whether it's a parochial school, a military school, whatever kind of private school. Anyhow, I don't want to dwell too much on the factual background of the Pierce case, although as you can see, I think it was all quite fascinating. Let's get to the result. So the result was the Supreme Court said, yes, there is a liberty interest here. The existence of private schools is okay under our Constitution. Parents have a right to have an influence in the training of their children. Those who want to run a private school have a business interest in running the school. But the state still has an interest in making sure that all kids are prepared for citizenship. So what they came up with is what Professor Mark Udoff called the Pierce Compromise. And the Pierce Compromise was that private schools can exist, they have a constitutional right to exist, but the state has a constitutional right, and I would say an obligation, to regulate the schools to make sure that they are properly preparing the kids for citizenship. Here's the key phrase, the key quote from the U.S. Supreme Court in the Pierce case. No question is raised concerning the power of the state reasonably to regulate all schools, to inspect, supervise, and examine them, their teachers and pupils, to require that all children of proper age attend some school, that teachers shall be of good moral character and patriotic disposition, that certain studies plainly essential to good citizenship must be taught, and that nothing be taught which is manifestly inimical to the public welfare. So that's the Pierce Compromise. It's still the law. The Supreme Court has never taken any of this back. States have an obligation to regulate private schools to make sure that they're teaching good citizenship. The states have not always effectively undertaken that responsibility, but that is the constitutional understanding. I don't have time to get into this whole interesting history of how private schools have developed and how some of them may not be teaching good citizenship, but let's go back to the public schools. In any event, I wanted to do this quick historical overview to just establish how important this central fact of the responsibility to prepare kids for capable citizenship, how far back it goes in our history. It was the essence of the reason why schools were founded, why compulsory education was put into effect. So moving up to modern times, the question is how well are schools carrying out this responsibility? And now I'm going to talk about the public schools, the private schools, a whole other sector. I think it's fair to say that at least over the past 50 years or so, the schools have largely defaulted on this responsibility. We can look at the results of our educational process, which Robert Putnam did in his famous book, Bowling Alone. That was written, I think, in the year 2000. So looking back, he documented how since about 1960, we've had this huge fall off in civic involvement of young people, of all people in the society, but really the young, because he compared the World War II generation, the grandparents with their children and grandchildren, and essentially found that involvement in civic organization, voting patterns, all of the indicia of active citizenship had declined roughly 50% over that time period. And he did attribute some of it to what was going on in the schools. He attributed it to other factors. Many other groups have been very concerned about the civic preparation of children, have further looked into these issues, and there are a slew of surveys, tests that have been given to high school seniors, college students, that document the abysmal lack of knowledge about basic civic facts that the majority of our young people seem to exhibit. You're probably familiar with a lot of these. 50% of students could not name the 3 branches of government on a recent exam. 73% did not know that the Bill of Rights bans official religions. voter turnout for young people, with maybe the exception of 2008. Maybe we'll have an exception with the Bernie Sanders revolution in 2016, but generally over the last 50 or 60 years, the pattern has been young people voting much less than 50%. Without, again, belaboring the point, let me just summarize this perspective on where the schools are today in terms of their responsibility to prepare students for civic participation. The U.S. State Department, in a report, U.S. Department of Education, in a report issued in 2012, stated, quote, "Unfortunately, civic learning and democratic engagements are add-ons rather than essential parts of the core academic mission in too many schools and on too many college campuses today. Many elementary and secondary schools are pushing civics and service learning to the sidelines, mistakenly treating education for citizenship as a distraction from preparing students for college-level math, English, and other core subjects." Okay, so my premise going forward, and going forward for me means starting to talk about the role of the courts in all this, is that there's a problem. And the problem is the schools have this fundamental mission to prepare students for civic participation. It's their historical purpose for being, and they're not doing a very good job in the 21st century in carrying it out. So where do the courts come into this? Well, let me begin by telling you that 24 of the highest courts in 24 states have specifically held that preparing kids for civic participation is the prime purpose of education, or one of the 2 or 3 prime purposes of education. And this is in recent years. They're not talking there about 100 years ago or 200 years ago. In making these statements, many of them have gone back in history and have looked at the original intent of the people who wrote these constitutional clauses that the courts were interpreting, and that may have been 200 years ago. The provision in the Massachusetts Constitution that John Adams himself wrote in the 1780s is still in the Massachusetts Constitution. So when a case came up, that's what they interpreted. What did John Adams mean? Well, we know what he meant, and now the courts have reiterated in an originalist approach that Justice Scalia would have very much gone along with, I guess, that John Adams meant that the purpose of the schools is to prepare revolutionary citizens and on an egalitarian basis, and that's still what the Constitution requires. Mira mentioned the CFE litigation in which I participated in New York State, and the court there very much emphasized this responsibility for civic participation. The definition of what a sound basic education is that the New York Court of Appeals articulated in our case was that all students must be given a meaningful opportunity to develop the skills needed to function productively as civic participants. And they gave a couple of examples, civic participants who could vote capably and serve on a jury. So those were a couple of the examples of what they meant by civic participation. Very strong statement of what the constitutional requirements was. The CFE, the language we had in New York was from the Common School era. So Massachusetts, they were interpreting the Revolutionary War era. In the New York case, they were interpreting language written in the Common School era. I want to bring to your attention one other of these 24 states that have spoken about this, but you've got wonderful language along these lines in just about every one of these cases. But in Kentucky, they wrote a very influential statement of what an efficient education is. That's the language in the Kentucky Constitution. All these clauses in the different states may have different language depending when they were written, but when the courts interpret them, they come back to saying whether they use the phrase efficient. In New York, our language was the legislature shall establish and maintain a system of common schools, still have that archaic language in which all the children shall be educated. In Kentucky, it was that they shall establish an efficient system. That language was also written during the Common School era, and the Kentucky court went back in great detail in quoting from the debates at the time of the Constitutional Convention, and all of this language along the lines of what I quoted from Horace Mann is what they focused on. So, you might say the Kentucky court was more of a living constitution approach than Justice Scalia would have liked, but whether you go back to the original intent, textual interpretation, or living constitution, what does it mean for our times, the courts seem to come up with the same bottom line. So for the Kentucky Supreme Court, what an efficient education in a common school means for them it was the 20th century, it was in the late 1990s, was that the state must have as a goal the development in each and every child of the following 7 capacities. And there's the specificity here is really instructive. 7 capacities are part of the constitutional requirement in Kentucky. They are: 1, developing every child. 1, sufficient oral and written communication skills to enable students to function in a complex and rapidly changing civilization. 2, sufficient knowledge of economic, social, and political systems to enable the student to make informed choices. 3, sufficient understanding of government processes to enable the student to understand the issues that affect his or her community, state, and nation. 4, sufficient self-knowledge and knowledge of his or her mental and physical wellness. 5, sufficient grounding in the arts to enable each student to appreciate his or her cultural and historical heritage. 6, sufficient training or preparation for advanced training in either academic or vocational fields, so to enable each child to choose and pursue life work intelligently, and sufficient levels of academic or vocational skills to enter the competitive job marketplace. That court focused mainly on citizenship, added preparation for the job market, which many of the courts do, I should say. Generally, out of these 24 courts, they say the purpose of education in the 21st century is preparing kids for capable citizenship and for competitive employment. We're focusing today on the capable citizenship part. But as you can see, bringing this history forward through this constitutional analysis is both a fascinating academic exercise to see how that language still lives, the language from the 18th and the 19th century, but in a more direct advocacy sense, I would say it's highly significant for the fact that this is the constitutional requirement. So if the schools have not been carrying out their responsibilities in this area, they are not complying with the Constitution. And bringing those two realities together is what I'm trying to do in the present research I'm doing, and what I have in mind for putting together in a book, and maybe for some future litigations. So let me just talk about the legal setting here and how this legal perspective might be developed. As I indicated, most, not all, but about 19 out of these 24 decisions that I'm referring to came from the so-called adequacy cases, and that's what our CFE case was in New York, that's what the Kentucky case was, that's what the Massachusetts case was. And an adequacy case basically was a claim by a group of plaintiffs, parents of school children, in some cases it's been unions or school districts, but the claim was that the state education funding system was unconstitutional because it was not providing sufficient resources, enough money, for kids to get a basic education, whatever the basic education required by the Constitution is. And the reason the courts got into this question of going back in history and trying to figure out what the people who wrote these constitutional clauses meant is, before you can figure out how much money should be spent in the schools, the courts, thinking kind of logically, said, well, we first have to make clear what's the purpose of the schools. What is it they should be doing? Then we can look at how good a job they're doing and how much money they need to do it. But the first point is, what is the purpose of education? So that's why so many of these courts have gone back and looked for that original meaning of the Constitution. I should say, by the way, when I mentioned the 24 states have explicitly said in the 20th or 21st century that capable citizenship is one of the prime purposes of education, that's not to imply that the other 26 states said something different. The other 26 states just haven't spoken about it yet. But there's not one state that ever denied that the purpose of education, or one of the purposes, still is capable citizenship. Okay, so what's happened with most of the education adequacy cases, plaintiffs have won the majority of these cases. There have been litigations in 45 out of the 50 states. Plaintiffs have won about 60% of these cases. And, of course, the motivation for bringing the cases was to get more money. So in the cases where the plaintiffs win, and you get to the remedy stage, what's the court going to do about it? The big focus is on how much money does the state have to cough up to comply with the Constitution. And I will admit that's what my clients were interested in New York when we brought the CFE case. And on that count, we did pretty well, at least in the initial settlements after the court order in 2007. The bottom line in New York State was that the state was committed to increasing spending on public education throughout the state by $7 billion. $4 billion for New York City, $3 billion for high-need districts throughout the rest of the state. So we thought that was a pretty darn good outcome. We were very happy with it. And it was going to be a 4-year phase-in. Everything went very well for the first 2 years. But in year 3, the 2008 recession really started again. So then we started having some compliance problems. First, the state froze any further increases. Then they started cutting dramatically around 2010. And we've been trying to get back to where we should be ever since. And as they're indicated, we're back in court and all the rest, looking for that lost money. But just to give you the personal awakening I got on this, I was very interested in the court's definition, the emphasis on civic participation. And in fact, we had to spend a fair amount of time at the trial trying to develop on the legal record what are the skills that kids need to be civic participants. That was one of the big issues at our trial, and we spent a lot of time on it, and the court came up with some very interesting conclusions on that, which I'll mention later. But as far as this question of what the remedy, what they should do about it is, to the extent that we were aware and concerned about the school's ability to prepare kids for civic preparation, it was sort of implicitly understood that if they really got $7 billion, they'd be able to do such a great job in overcoming achievement gaps, in improving curriculum in general, that this would kind of take care of itself, that with the extra resources, we would expect the schools would do whatever they needed to do to prepare all kids to be capable citizens. But what I realized when we started having problems after the recession was that this problem of preparing kids for civic participation was more deeply entrenched than I had realized. And one thing that really struck me as being hugely problematic was a couple of years after the recession hit and after the schools started getting these huge cutbacks, we went out to see what's the impact of the cutback in funding on schools, mainly high-need schools in high-poverty areas. And we visited about 30 schools in New York City throughout New York State. And one consistent pattern we saw in just about every one of these schools was the first thing to be cut when money was scarce was extracurricular activities or art, music, all the kinds of places where kids would have learned the interpersonal skills, to have the experience in things like moot courts, visits to state legislatures, active service learning, all of the positive aspects of preparing kids most directly for civic participation were considered expendable. How much they were dealt with in the good times, we didn't have a record of, but in the bad times it was clear that these schools were not carrying out the function that the court said was their primary obligation. So that's when I realized that there's a very serious problem here. It has added dimensions for low income, for kids of color, as Mira has so well documented in her book. So there's an equity dimension to this that's very serious. And that started me thinking about maybe in CFE and other cases like this, we should be asking the courts to do more than just issue an order that they've got to spend more money. So whenever I mention that I'm working on this topic, first thing people ask me is, well, what can courts do? Let's assume you're right, that there's some kind of constitutional right here. How does having the courts interfere in this help anything? Well, just from the example I spoke about over the last few minutes, extracurricular activities, art, music, and all, be very simple for the New York Court of Appeals or another state court, Kentucky court or whatever, to issue an order that extracurricular activities are mandatory. And recession or not, fiscal constraints or not, you can't cut those any more than you can cut English, math, or other things. And I think that not only would have a salutary effect on providing some base funding for extracurricular activities, but I think it would start people, would jumpstart people thinking more directly about how important this preparation for civic engagement is, and how the schools have not been doing what they need to do. Many of you may know Peter Levine heads the Circle organization at Tufts University. He's been a real pioneer, a really forceful advocate for greater emphasis in the schools on civic participation. And you know, as I've started getting into this area and reading all the great books that Peter and Mira and Helen's articles and all, I realized, you know, there are a lot of people doing a lot of work in outlining what good practice would be in the schools, how schools really could make a difference in civic preparation, how they can respond to the challenges of the 21st century, the internet, media, realities of a much more diverse population and all. A lot of good ideas out there, a lot of examples of schools that have been successful in these ways. But on a general basis, our public school systems are not adopting a lot of these practices and theories, are not seriously looking into this problem and doing anything about it. At one point, one of his books, Peter Levine said, quote, "These problems can be solved only if an outside power applies leverage to the priorities of the school." An outside power applies leverage. Now, he meant the government or a social movement somehow needs to pressure the schools, because all the advocacy work he's doing, all the academic writing, all the demonstration projects have not had any huge impact on the public school systems at large. Well, my fundamental premise is the government, if that, you mean by that you mean state legislatures, they haven't done anything for the last 50 years. They're not likely to. Social movements, maybe, but I haven't seen any on the horizon that have made a difference. So my perspective is the courts can do this. They can apply the leverage. They can have some mandatory muscle here, and they can make the difference. I will also acknowledge that part of the problem here, part of the difficulty in getting schools to focus on things like deliberative democracy discussions, having kids discuss seriously controversial issues. These are some of the things that Helen and Peter and others in the area think are really important for preparing kids in the 21st century. We don't have as much of that as we should, partially because the courts have had a chilling effect in some ways on administrators, on teachers, who are sometimes hesitant to venture into these areas because they're afraid of crossing some shadow lines of what's allowed, what's not allowed, now that the courts have said that kids have First Amendment freedoms, that there are due process rights in the school. There's a lot of controversy about all these legal issues that have entered into the school environment. So I do think we need more clarification from the courts in many of these areas about what some of these impacts are. You can see a lot of these requirements, due process, for instance, that you, from a teacher's point of view, they often feel inhibited in suspending and expelling kids because they have to have all these hearings and people are looking over their shoulders, courts are looking over their shoulders. But you know, you can turn that around. The fact that there are requirements, legal requirements, constitutional requirements for due process hearings means you also have a wonderful opportunity to apply Dewey in theory about involving students in understanding governmental processes and understanding rights, in taking part in some of these disciplinary procedures and all. So there's a lot of potential there, but there's got to be a lot more clarification for that kind of potential to go forward. So in a nutshell, people have not asked the courts in these 24 cases and many other cases to come up with specific remedies, and my premise is it's about time that we, and when I say we, I mean lawyers, I mean academic legal scholars, I mean people in general concerned about civic participation. What kind of orders would be helpful from the courts? How do we get the courts to focus on these? How likely are they to do this? I do think a lot of the state court justices would be open to this, would be right for responding to this. I must say that recent developments, the fact that we've got an open seat on the U.S. Supreme Court, and the balance may well tip in the direction of more open thinking, may raise possibilities for getting the U.S. Supreme Court to refocus on the implications of what they said in the Pierce case almost 100 years ago, and what they said in the Rodriguez case 40 years ago, which is what started this whole huge movement of state courts looking at fiscal equity and whether there are enough resources in the public schools. All the state courts got into this only because the U.S. federal court, the U.S. Supreme Court said there's essentially no right to education under the federal Constitution. Well, with a more, how do I put it, less conservative Supreme Court being a real possibility now, may be possible to open that up. And part of what was going on in Rodriguez was whether there, as the state courts have said, a federal right to some basic amount of schooling that you need to be a capable citizen. And the Supreme Court talked about that in dicta. It was not part of its holding. They were concerned about that. They said at the time that the case that was brought from Texas, nobody said those kids were not getting enough education to exercise their First Amendment free speech rights, to exercise their voter rights under the 15th Amendment, so the court didn't reach that issue. The issue they saw was that in Texas at the time, some districts were getting more money than others, and the court just held the federal Constitution doesn't deal with relative amounts of money among school districts. If you're worried about that, go to the state courts, but the federal courts aren't going to deal with it. Well, maybe they will deal with it a little more directly in the next few years. So there is huge potential here, and I will be very interested in hearing Brent's response as to how plausible he thinks this all is, and I'll be very interested to hear your comments, suggestions, and criticisms of the possibilities involved in going down this route. Thank you.
Thanks, Mike. Should I give you that, please? You keep it. Hearing your responses to the questions is much more important than my questions. Well, thank you. In many ways, I think you're singing the song of CMEI, that we know that there is a civic empowerment gap. We know that the results of civic education are not what we hope or desire. And I think, at least it was welcome news to me to know the courts do have a stake, that they have a record of responding or stating the civic responsibilities of schools, and the courts themselves have a responsibility for ensuring it. What is less clear to me as a non-legal scholar, perhaps I'm what we ubiquitously talk about here as a naive but hopefully intelligent audience. I wonder about what mechanisms the court would use to ensure the kinds of civic education in which we are most interested in. For example, how would a judiciary enforce the kinds of civic education we talk about as new civics rather than old civics? Not just voting, not just knowing 3 branches of government, but educating for some agentic responsibilities, some action in their community responding to specific needs. I'm especially curious about how the court would ensure that a state does not respond, as some have, with civic education that is whitewashed, it glosses over the most inconvenient parts of our history, of our civic past, and those stories, obscuring the stories that focus on women, African Americans, Latinas, and other minorities. So, in other words, how could a court advance a new civics agenda and ensure that we achieve the kinds of outcomes in which we're most interested as new civics scholars? And part of that is, how do educators maintain their voice in what civics education is when they're responding to a court ruling? And then what are the mechanisms of enforcement that a court might have? And especially, how might they compete with the sticks that are often threatening from legislatures in terms of withdrawals of funding or withdrawals of school autonomy if they do not meet certain high-stakes testing thresholds? And related to the mechanisms of enforcement, what thresholds might you conceive courts considering for civic engagement, and by what measure might they use to establish those thresholds? Those are the questions that I have to offer, so I look forward to hearing your response, and then we'll open it up to questions from the audience.
Okay, well, thank you very much, Brent. That was very well put. Those are pretty much the questions that I'm spending the bulk of this year on sabbatical trying to wrestle with in writing a book about this and then possibly putting together a litigation. Let me answer generally the thrust of the question about mechanisms by saying courts in these kinds of situations do not micromanage the details of what schools or legislatures should be doing. They put out general requirements that essentially say this is a responsibility of another branch of government, whether we're talking about the legislature or a state ed department, which is part of the administrative, executive branch of government. they're not doing their job right. We're going to give them some general parameters and expect them to go forward and fill in the details. So for instance, on the money part of these adequacy cases, very rare for a court to say, you need to spend X number of dollars. The court didn't issue an order saying New York had to spend $7 billion. What they did do is issue an order that said, you have to do a credible analysis of what is the actual cost of providing a sound basic education as we've defined it. So they were telling the state, which in the past always decided how much money they were spending on education by political wheeler dealing in the back room when it came to budget time, and it was, you know, really an exercise in who had more political power. That's what districts got the most money. They said, no, you can't do it that way. That's not constitutional. It has to be need-based, and you have to do it through a regular process that is focused on the actual costs on a need basis. All right, so then the governor set up a commission. They hired all kinds of consultants who do fiscal equity analysis, and we did get into some battles because as plaintiffs, we had some experts who did cost studies, the state had experts, but you were dealing in a different realm. You had expertise being applied to the question, and you had differing responses, and that's part of the democratic process. Courts don't take over these whole areas. They're not going to take over the schools and supervise them to make sure that they're implementing the new civics or anything else. But what they can do is establish these parameters. And I mentioned they can say that there has to be a reasonable range of extracurricular activities, that arts and music must be considered high priorities. Other things they might do is, for instance, state that the schools in a democratic society must appropriately teach values of tolerance and democratic deliberation. Now, what does that mean exactly? How far are you going to go? Are you going to teach controversial subjects? How controversial? There's all kinds of literature about how far you go with these things. And as you mentioned, how do they assess whether the schools have been successful? They can order the states to come up with meaningful systems of assessing whether kids are in fact learning the skills, the knowledge, the values they need for civic participation, and leave it to the states to develop those tools. And a lot of people are working on that. If the courts were to come out with this, it means a couple of things. It means there's a whole new focus on moving in the right direction. A lot of work's being done now. It raises that to a much higher priority level in the public view, in the legislative view, within the various priorities in the school. That's the first thing. It gets more resources focused in that area, and it allows people to really think through on a mass basis, how do we go about doing this? Now, is it going to be done perfectly? No. Is it going to be done better than it's being done now? I think yes. So democracy is an imperfect mechanism. And the court's role in this is to establish priorities, to move things in another direction, to move resources. But if this were to happen, it would be up to people like you to carry forward and develop the expertise and go to the legislatures and go to school principals and make sure that it's being done right. Now, as far as the content of what some of these court orders may look like, as I mentioned, this is something I'm working very hard on. And in my mind at the present time, and this is very much in an early stage of development, I'm thinking about 5 areas of emphasis that courts should be looking for, which I think to some extent lines up with the new civics, but quite frankly probably doesn't go as far as many people in this room would, because if you're talking about courts, they are concerned about consensus, about not getting too far out in front of what the public might accept, or the legislatures might accept, but they would be willing to push the envelope to some extent. So the 5 themes that I would like to figure out a way to get into court decisions and court orders are a focus on making positive use of the growing diversity in the schools, focusing on deep learning, not superficial multiple choice type approaches to civic knowledge, serious attempts at equal opportunity, because civic participation has to be based on building trust within diverse populations, and you can't have that with the huge gaps in resources and tracking systems and things like that. Trying to spell out deliberative democracy and what that means and how important that is for developing the skills kids need, and then also talking about civic values, which would incorporate a lot of the values that people on the more conservative end of concern about civic engagement emphasize, and I don't think people on the more progressive end necessarily disagree with them, but they would go much further. But to build this kind of consensus that courts would think is reasonable and plausible, I think you do have to get into issues like teaching children respect and self-restraint and patriotism, which is a difficult one to wrestle with, but has to be in the mix. So those are the kinds of things that I'm talking about. The last thing I'll mention in response to Brent's comments, how do courts enforce this? If they issue an order like this and it's totally ignored, what happens? Well, what's happened in the funding cases and in some other areas where courts get involved in policy, generally there's compliance to varying extents. Sometimes there's outright resistance. And we certainly knew that in the desegregation days. But desegregation, dealing with really intense racial issues, is a whole separate area of legal development. I'd rather talk about the fiscal equity cases where the compliance has been greater, and even when there's non-compliance, the 2 branches, the 3 branches, tend to work it out in a different way. When you get to the bottom line, when there's outright compliance, when even with the courts doing follow-up orders and trying to push the legislatures gently and all, when it doesn't work, you may get down to a circumstance like where we are in Kansas as of last week. There's been a back and forth in the Kansas legislature about whether the legislature was complying with past orders to equalize funding to some degree in Kansas, and you have a governor there and a legislature that are very resistant, both to the idea of the courts ordering them anything and to the idea of having to raise taxes to provide more money for the schools. So the courts run out of patience, and in a decision issued last Thursday, they laid down the law. And they said, we're telling you how much extra money you have to provide for the high-need schools, which they cut drastically in the last couple of years. They directly refused to comply with a prior court order. So the court now said, either you give these schools the extra money that they're entitled to under the equity part of our state constitution, or, and do it by June 30th, they're giving until June 30th, or effective July 1st, there can be no more funding for an unconstitutional system in the state of Kansas, and all public schools will be shut down for the next school year. So that is the order that was issued last week, and we're going to have a nice game of gunshot at the OK Corral. Who's going to blink first? I can tell you courts have threatened this, I call it the atomic bomb, a remedy that courts can come up with. It's been threatened seriously 3 times before. Once in New Jersey, once in Kansas, and once before in Kansas, and once in Texas. So far, on those 3 prior occasions, the court got what they wanted. They never shut down the school systems, and we got compliance. Stay tuned. You ought to look at your papers in June 30th or July 1st and see who blinks on this one. But that's the ultimate remedy, and courts can do that if they have to. There are a lot of remedies short of that. Okay, so I hope those were satisfactory responses. Yes?
Question, you know, I wonder sometimes whether as educators we haven't provided the courts with good information. The private schools are required to file 990s, and I don't know if you're familiar with them and what's reported in the 990 tax filings.
Right.
But if you look at the 990 tax filings, you can find private schools that are spending $78,000 per pupil annually by taking their expenses and dividing it by the student population. Similarly, you can go in and disaggregate the 990 filings and look at specific vendor expenditures within the 990. So if Aramark is a food service, you can find out that they're spending $35 a day on food service per student. And the federal lunch program reimburses, you know, $1.35 a meal for reduced or free lunch. So you can begin to make some rather stark comparisons between a high school principal in a district, Belmont, making $135,000, and someone with comparable responsibility in a private school whose compensation package is $765,000. So when you start to look at the fact that databases are available to present wide-ranging discrepancies in expenditures, and not only that, but the social compact that was formed back in time to give these private and nonprofit institutions basically equal standing with government institutions because they were providing similar services. And folks had the right to assemble and offer private education. But we gave them a tax break in terms of giving them tax-free status. And in addition, contributions made to their endowments were tax-free. So we gave them another type of, and so there's a very heavy leaning there. But when you find somebody then paying $3 million for their football coach with that money, what kind of abuse is involved there in the original social compact that was drawn up? So I wonder if we shouldn't be working some of these databases and presenting this information more publicly to demand equitable, because what happens in the state reform...
Can I just ask you to finish up your question?
Yeah, what happens in the state reform initiatives is you end up with some kind of deal struck for mediocrity rather than a real creation of equity.
Yeah. I guess the theory that permeates most of our society on those kinds of issues in private schools is that's an issue for the marketplace, that yes, there should be more transparent reporting here, and I guess if many of the parents who send their kids to these private schools did the digging into the 990s that you're doing, they might have something to say about principals getting $750,000 and all. The extent to which the state gets into it, you know, there have been cases where private schools were blatantly racist and the IRS pulled their tax exemption. But I guess that would be the entry point. The public authorities do have a right to regulate private schools for teaching good citizenship, as I read, but also, I guess, to regulate them for efficiency and all if they wanted to. Whether any of them would is not a question I've thought about, to be honest with you. Any other questions?
Well, you said that state legislatures hadn't done anything in 50 years. And I would counter that the Massachusetts Reform Act of 1993 really did something. And civic education was part of it. In the Patrick administration, they took the requirement of a history standard for graduation out that was in the original law. And that was, it's not necessarily causal, but at that moment that they did that, Massachusetts LEAP scores stopped going up for English. And so it seemed to me, and the legislature has been polled on this, and they said, no, we don't like this, but nobody has gone and said this. I mean,
So you mean the legislature's done something in a negative sense?
well, the legislature didn't do anything. The legislature wrote it in the law.
Yeah.
That this part, civic education, had to be part of the graduation requirement. The executive branch, on the guise of budget cuts, got rid of them. And it looks, if you look at the overall 10th grade NEEP scores, that, you know, they were climbing for years, and was absolutely corresponded to 1993 Reform Act, that the performance of Massachusetts schools improved radically. And, you know, they've stopped improving in the last 4 or 5 years.
And you see a direct tie?
I mean, it's just a correlation, it's not, there's no way, but that happened in Massachusetts. And, you know, it was just a case where the legislature didn't demand that the executive do what they had asked them to do, and nobody sued.
Well, you know, generally throughout the country, there was a clear pattern, and this has been documented, that schools tended to cut back the amount of time devoted to social studies, civics, in addition to cutting extracurricular. De-emphasis on all of this, and that had to do with the No Child Left Behind Act and the heavy premium that's put on standardized test scores in math and English, science to some extent. So this is all part of the mix of why I'm saying if the courts came in and established some basic mandates for what core subject areas are that can't be cut even in times of recession, it might be able to deal with the problem you mentioned and a lot of other similar situations.
Thank you for your talk. It raises lots of questions, and I'm glad you brought up the standards-based reform aspect, because I focus a lot on that. So one of the things that I did several years ago is try to understand when there is a formal requirement for different kinds of curricular opportunities, such as the arts, what happens under standards-based reform. And I did a study in Kentucky and, Virginia, and found that across different districts, the opportunity remains in the formal structure. So 45 minutes of art once a week, and the FTEs remain the same. But what happens is, within the guts of the course, it's hollowed out to teach toward the standards, especially in the poor districts. So getting into the nitty-gritty of what a real opportunity looks like can be, as we all know, pretty challenging. You can have things on the books that no longer look like what they're supposed to look like.
Right. Well, again, what I've got to say is solving these huge problems of public policy is not something the courts can wave a magic wand and fully accomplish. What they do is get into the mix of the political and substantive issues that have to be dealt with, and give extra leverage and extra tools to certain perspectives on how the problem should be dealt with. But it does require continued advocacy, continued academic focus on what should be done. It just raises the stakes a bit and makes it a higher priority, gives it more resources. But I think that can make a huge difference. It has in the funding area, and I think it could in this area.
Just a brief follow-up. I also think, though, that we're at a good point to try this again because of the new ESSA opportunities that are allowing states to devise more of their own accountability systems. So
Right. Yeah, the ESSA does give a lot of possibilities because it allows states to do a lot more things, but on the other hand, the historical record from a civil rights perspective has been that the big advances tend to come when the federal government takes a stronger stance. So we'll have to see. Yeah.
Going back to the Ed Reform Act of '93, it established a net school spending requirement for communities in Massachusetts. There are many communities that don't meet, or several communities that don't meet their net school spending requirement, and nothing really is done. Whereas schools that don't meet performance standards in their testing batteries, you know, they beat up on the school and sometimes beat up on the teachers in the school as a measure of non-performance. That happens. Those schools are placed on probation, they're put under pressure. There's news articles, but I don't think you could pick a single legislature that could tell you what schools are spending at the net school spending level.
And which are they? Are they the high poverty schools or?
Well, I know that, I'll just pick a name. Lynn doesn't meet its net school spending requirement and is $1 million short. And the question is, can the courts do anything about that?
Well, probably they could. As you may know, that '93 Act was very much tied in with a pending adequacy litigation at the time. And you know, when I mentioned the Massachusetts Supreme Judicial Court interpreted John Adams' phrases from the 1780 clause in the Constitution, it was in that case. So I think that lawsuit had a lot to do with enacting that law, and I think over the years Massachusetts increased spending for public education on the order of $10 billion. Now, that doesn't solve everything, and there are problems that develop along the way. There was another case brought in Massachusetts 5 or 6 years ago, you're probably familiar with the Hancock case, where the trial court wanted to order the legislature to focus more directly on high-need districts that were not doing as well as the rest of the state. But the court, in its wisdom, looked at the situation and said, this state has made a lot of progress, it's doing much better than most other states, and we're not going to interfere with the legislature. They didn't say they didn't have more work to do. They just said they've been moving in a progressive direction, so we're not going to get in their way. Now, I don't know what the facts are now. Maybe it's time to go back to the court. Again, you know, I don't want to give away all the strategic tools that we use in bringing these litigations, but I mentioned that Justice Scalia's death opens up a lot of possibilities on the federal court. I do know Judge Botsworth, who had decided that Hancock case about 6 years ago in favor of the plaintiffs and said the legislature's not doing enough. She was overruled by the Supreme Judicial Court at the time. Well, she's now on the Supreme Judicial Court, so there may be a change in the balance there too. These are ongoing situations, and if the courts get involved, again, it doesn't magically solve all problems overnight, but it's another strategic tool that can be used depending on what the problems are and how they develop. What's the best means of dealing with them? That's really the way we look at them.
I'm intrigued by a problem which I think is in this kind of field, where there's a lot of apparent common sense on what we believe we understand by the definition of terms, and what we also recognize as likely resistances. And I find the fact that, you know, you avoided defining what a good citizen would be, or what a good citizen, what education that good citizen would be. Presumably because at the moment, in the context that you're talking about, nobody actually does sit down and define a vague concept of what a good citizen is, and they have a fairly vague concept about what elements of education, and particularly what kinds of knowledge and skills people would have to define that term. And one's first response is to say, well, look, let's have a fantastically clear definition of what a good citizen is, and what would constitute that if we decided to define the requirements, but also the mechanism to acquire those skills. But then that seems to be kind of quite problematic, because once you start engaging in something which in effect could be tested, which is the way you get things done in most countries, you can test it, you can actually implement it. There is a problem that we're in a fairly transitional state in deciding what we think the terms are. The term new civics has come up. New civics is a very exciting development at a number of different levels, from the most the minutiae of what a pre-K kid might do in a circle class to what it might be holding theories of democracy. I think that there is a tension, because if we want to try and do the implementation we're talking about, somebody's going to say sometime, well, how have we really done it? What would be the criteria of success? And once you start asking that, then people will say, well, there's no criteria of success everybody agrees about, so we can't implement it. Or they might say, let's develop criteria of success, but then how do you arrive at a consensus that everybody will accept without it being watered down to something which is actually not very helpful at all? I mean, we've had this to some extent in Britain. We implemented a citizenship curriculum about 15 years ago. A bit longer than that, we began doing it, probably 20 years ago we began doing it. Initially it was really exciting. Initially it was really innovative, looked like the kind of thing we might call new civics. It's now been watered down to something that's little more than a knowledge test, and often rather trivial knowledge test at that. And I mean, I'm just thinking there are fantastic opportunities now in the States to really do something exciting. There's also danger in where you put the pressures at particular times. And I'd like to know what you think about that from a legal point of view.
Well, for one thing, litigations tend to be very fact-specific.
Yeah.
So if we were to go forward on this, you would get some test cases. And I would want to consult with people like you and say, where are the pressure points? Where are the vulnerabilities? Where can we show good examples of something that a judge would consider negative and want to do something about? And that might lead to a strong definition in the direction that you're talking about. Doesn't protect it that way forever. If a court orders a way of assessing what a good citizen is that you would find very helpful, and in the year 2018 or whenever this may happen, it might make a lot of sense. 5 years later, if you've got a very different legislature, you don't necessarily get protection from it, but we have to deal with things a step at a time. And I do think that having this much more out in the open and having courts weigh in on it can make a huge difference. And you know, in our CFE case, by the way, I mentioned we did a lot of work at the trial in trying to determine what skills kids need to be good civic participants. And when the Court of Appeals first came up with a tentative definition in this area and said that at the trial, the lawyers and their experts should give the court much more information about whether their tentative definition was right, should they put this focus on civic participation? If so, what does that mean? They were asking those questions. And, you know, as a group of lawyers, when we got that original decision, we were scratching our heads. You know, what do we know about what skills kids need to be good citizens, and how are we going to show this at court? And I know Maher's heard this story, but for the rest of you, I do like recounting it. So we're scratching our heads. How do we show what skills kids need? And the trial had started that year in October. We were just at the beginning of what turned out to be a 7-month trial. When election day came, so there was no court on election day. We'd come in the day after, and before we had any witnesses and all, the judge calls all the counsel up to the bench. You know, those little private conversations you see on Law and Order and all. And this is what he said to us. He said, you know, I was thinking about this case when I went to vote yesterday. And the Court of Appeals said that we should figure out what skills kids need, among other things, to be voters. So here's what I want you to do. I want your expert witnesses to focus on the ballot proposition that I had a vote on yesterday. And this was some complex thing with all kinds of legal jargon about changing the structure of the city council, and we had a board of estimate then in New York, raised all kinds of separation of powers issues, and it was a lengthy ballot proposition. So he said, I want your experts to focus on whether graduates of New York City's high schools can comprehend that ballot proposition. And then he said, and while you're at it, the court also talked about jury service. They're having a product liability case in the next courtroom. I want you to get some of the documents that are going to the jury in that case, and tell me again whether graduates of New York City's high schools can understand those documents. So that was the focus of our proof. And what we did is, we had education experts. We had Linda Darling-Hammond, a number of other people who took the state standards in English, in social studies, in science, and we put them on one screen. On the other screen, we took the language from this ballot proposition, and Linda went through it back and forth to comprehend that sentence that's on the ballot proposition. You need these 3 skills that are called for in the state standards. And to make sense out of this product liability thing, you have to have the kind of knowledge that is required to pass the science exams in New York State. So what we were able to do is show that the skills you needed to answer those questions were related to the new standards at the time that the state was putting into effect. And the state's argument with us, by the way, was that a minimum sound basic education should correlate with 6th to 8th grade functioning in language arts and the other subjects. And we were saying, no, it has to be 12th grade level. We have these new standards. The standards should define what the level of required education is. So we did establish to the court's satisfaction that you needed the much higher functioning levels if these are indeed the skills. And the language the judge used in his decision, if you go back and look at it, I think you'll find it really kind of extraordinary. You talk about deep knowledge, are we going to have superficial knowledge of government and all? He says right out that in the 21st century, students need the kind of skills that are required to understand campaign finance law, laws, to understand the kind of language in that ballot proposition. Jurors need to know how to deal with DNA evidence and all kinds of other things that were there. So he was certainly coming in on the side that we have to have a very solid basic education for all kids, because there was a real emphasis on low-income kids. And by the way, you'll probably be interested in this, and I'm sure we're running out of time, but I think I should give you the full picture. You might say, when we presented all this strong proof of the high level of literacy knowledge you needed, science knowledge and all, what did the state come in and say? They're going to say kids to understand a ballot proposition and all could be at 6th grade levels of reading? Well, they did try that, but that didn't work. But their bigger thrust was they had a social scientist from Boston University actually come in and talk about a range of polls that had been taken on actual voter behavior. And she established that something like 80% of citizens make up their minds on ballot propositions or on how to vote in general before they go into the voting booth, and they get that information either from newspapers at the time or from TV. It was before the internet was big. So basically, she was saying the kids don't need to develop high-level literacy skills and all, as long as they can watch TV and the anchor on the evening news can tell them to vote yes or no on this proposition, that's fine. And once we heard that testimony, we knew we won, because no judge in the 21st century is going to sign a decision that says 80% of the people can be functionally illiterate and be decent citizens. So that's what the court's going to do.